When you're working in data privacy law, a single word choice can make all the difference, right? We're talking compliance versus millions in fines. So welcome. In this explainer, we are going to build your legal English toolkit. We'll focus on the precise vocabulary and grammar you absolutely need to advise clients on data privacy and protection with total confidence. So, here's our game plan. We'll kick things off by nailing down that key difference between privacy and protection. Then, we'll get into the essential vocabulary and figure out who the key players are. And after that, we're going to zoom in on the specific grammar you'll use to talk about past and present compliance situations, which, is a huge part of legal reporting. All right, let's jump right in. You know this better than anyone. In legal work, precision is everything. And that starts right here, with the difference between data privacy and data protection. Now, in casual conversation, people use them interchangeably all the time. But for you, as a lawyer, they are two very distinct concepts with completely different legal weight. Let's break it down. Think of it like this. Data privacy is all about an individual's rights over their personal info. It answers the what and the why of data collection. Things like consent, fairness, transparency, this is what you'll be drafting into policies. Data protection, on the other hand, is the how. It's the nitty-gritty, the specific security measures and compliance frameworks like encryption or data breach plans that you'll advise clients to put in place to keep that data safe. And here's the crucial takeaway. The thing you have to get across to your clients, these two ideas are totally linked. You really can't have one without the other. Strong data protection is literally the foundation for real data privacy. It means you can't just promise privacy rights in a document. You have to back it up with effective technical security in the real world. Okay. Time to build up our vocabulary. These next few terms, well, they're the absolute building blocks for any legal document or client chat you're going to have in this area. First up, personal data. This is the cornerstone. And as a legal professional, you've got to appreciate just how incredibly broad this definition is, especially under regulations like the GDPR in Europe. We're not just talking about a name or an email. It could be an IP address, location data, even biometric info. The legal test is pretty straightforward. If it can be used to identify a living person, you treat it as personal data. Period. Next, the data subject. This is simply the formal legal term for the person whose data is being processed. In any privacy law you look at, whether it's GDPR or California's CCPA, the data subject is the star of the show. All the legal obligations are really there to protect their rights. Now, the data controller. This is the main decision maker. They're the ones who decide the purposes and means, the why and the how, of the data processing. In your day-to-day work, this is almost always going to be your client, which means they're the ones holding the primary legal liability. And then there's the data processor. The processor only acts on the controller's instructions. A perfect example is a cloud storage provider or a payroll company. You can probably guess why getting this distinction right, controller versus processor, is so incredibly important when you're drafting agreements and figuring out who's on the hook legally. Okay, so we've got the vocabulary down. Now let's map out the key players in this whole data privacy ecosystem. If you don't understand their different roles and, let's be honest, the tensions between them, it's going to be tough to navigate this legal landscape. So think of this as a constant dance. You've got the data controllers who are calling the shots and the data processors who are carrying out their orders. That relationship alone is a common source of legal disputes. Then you have the regulators, like the data protection authorities in the EU, who are watching over everyone, ready to enforce the law with audits and, yes, big fines. And right in the middle of it all, the data subjects, the actual people whose rights this whole framework is built to protect. All right, let's switch gears a bit and focus on some practical grammar. As a lawyer, you constantly have to talk about how things were. It's essential when you're explaining changes in the law or maybe outlining a client's compliance journey for a regulator. So, to talk about these past habits or situations that aren't true anymore, we use a really specific structure, used to followed by the base verb. For instance, the company used to store data without encryption. It's a simple little phrase, but it's incredibly precise for legal writing because it clearly signals a contrast between then and now, with zero ambiguity. So think about this for a second. Before big regulations like GDPR came along, how were things different? As we go through these next examples, imagine you're writing a legal brief. How would you phrase these changes? The grammar you choose really matters. Let's look at how this works in practice. You might write in a report, prior to the new regulations, the company used to share customer information without obtaining clear consent. Or maybe, historically, employees didn't used to receive any data privacy training. Using this grammar structure sends a very clear message to a court or a regulator that a past practice has been identified and, more importantly, has changed.
Okay, now let's pivot from the past to the present. This is the language you'll need to describe your client's current, ongoing, and, familiar compliance work, their day-to-day state of readiness.
Now listen closely, because this is a super common mistake that can really hurt your credibility. When you add the verb to be before used to, and then you follow it with the ing form of a verb, the meaning completely changes. It's no longer about a past habit. It's about a current state of being accustomed to something. Mixing these two up could seriously misrepresent your client's compliance status in a legal document. For example, you could confidently report that our client's cybersecurity team is used to performing daily vulnerability scans. See the difference? Or you could assure an auditor the company's legal team is used to applying GDPR requirements to all new ventures. This language shows that these aren't just one-off actions. They are routine, embedded procedures. It tells a story of your client's current, strong compliance posture.
Okay, let's bring all this together. We've talked vocabulary, we've talked grammar. So why does all this precision matter so much? Well, because in the world of data privacy, the stakes for your clients have never been higher.
The stakes are just incredibly high, and it's your job to make your clients understand this. This isn't just about ticking a box for regulatory compliance to avoid a fine. No, we're talking about protecting real people from real harm, like identity theft. We're talking about maintaining the customer trust that keeps the whole digital economy running. And honestly, we're talking about preserving some really fundamental democratic values in our digital society.
So how do you put all of this into practice? Well, here's a simple, powerful structure you can use for something as basic as a client voicemail. Greet them, state your purpose clearly, give them 3 key reasons why this matters to them. Use a quick, clear example, and then offer your support for what comes next. A framework like this shows you're not just an expert, but a clear, trusted advisor who's ready to help. And I'll leave you with one final thought, a question to chew on for your own practice. Of all the stakeholders we talked about, the controller, the processor, the regulator, or the data subject, who do you think is facing the biggest challenges right now? There isn't one single right answer, of course, but really thinking through the pressures on each of them, that's what will help you anticipate risks and give much more strategic advice to every client you work with.